scheduled for the purpose of dealing with the temporary protection order. That was, the motion was filed for that purpose. Mr. Merlis, Mr. Butkowski's position on the temporary protection order.
We've not assigned, we've not been served with a motion specific to temporary protection order. We've not seen that yet. That was provided to us. We did, between Mr. Walker and myself, we will be requesting a hearing on that motion for 2, 5, and 11 o'clock.
Judge, actually, I have the report, and I believe there's some attachments to it. I did not look through it. Judge, I was just appointed this morning to represent the interests of the state of Ohio.
Your Honor, there is currently in place a contact provisions as bond, or has been adhering to that, and intends to continue to do so. In addition to that, Your Honor, we made a motion this morning for retrieval of a specific piece of property. We're asking that you be permitted to return to the residence with a law enforcement officer to retrieve several items, whether they be work-related or personal. That has been served by the prosecutor this morning and filed this morning.
The motion. So you're for
Correct.
Yeah. The motion was part of the materials of the police report, and you haven't been.
Yeah, I get
that.
you see the schedule.
Okay.
We obviously like the opportunity to respect that.
I don't have it.
Judge, I think in the interim, you have no objection to a no contact, right?
Correct.
Mr. Mayor?
No, we have no problem.
Actually, I prefer to do an ex parte TPO, although trying to see if we prepared one of the answers. We have not. Only because the TPO is more thorough than this no contact order, although the no contact order is relatively thorough.
Judge, we want to send that back to the clerk's office. We can do a different case in the interim.
I think that's what I'd like to do.
We have a case involving the Department of Health.
Your Honor, I would ask that this is a judge that only the alleged victim be listed there. At this point, there is a ongoing domestic relations case.
I understand that.
We would ask that, at least as it pertains to the children, that this court defer to that court as it pertains to the young individuals involved here. I do not believe that there is an allegation of domestic violence against them.
Yeah, well, based upon what I think, the court did have an opportunity to review with the police department the factual circumstances, and the court believed that the children were involved in the incident, and therefore the children will remain protected parties under the no
When does
contact
the
order.
court intend to have a hearing on the ex parte order?
I'm sorry.
When does the court intend to have a hearing on the ex parte order?
Whatever is convenient for the parties.
Did we not agree on February 5th?
Well, I thought we were having a hearing on the order. The court's indicating desire to see the ex parte order. So we will have a hearing on that ex parte order as soon as possible. If it's going to involve.
Okay. Whatever's convenient for you, we're here.
Okay.
And Judge, we don't have a time waiver, so we also picked a trial date if it's an acceptable date to the court. That'd be February 12th at 11 a.m. Okay.
Would Friday work with the court for an ex parte hearing?
What's the date for it?
Tuesday or Thursday would be better.
Friday's the only day I have in the next 3 weeks.
We're not in session that day, though.
What's the date of that?
I was looking at 125 here.
Judge, I'd have to check my calendar.
The court's available on January 25th.
I could also do January the 29th.
The 25th and the 29th? Well, I'll check my calendar, and if Mr. Merrill filed a motion for return of some property, Your Honor, and I might also note, Judge, that Mr. Pecora, who represents the alleged victim in this criminal case, is in court. He represents her in the domestic relations act.
Right.
He's in court. He's also here as a Marcy's law advocate. desire that they remain separate.
So if we're looking for trouble, at least two people together. Anyway, let's deal with this motion for Mr. Butkowski to be able to go to the property. Yes, it's personal thing. So what is it that would be involved in that?
Your Honor, and again, we would have asked that he be permitted to return with a law enforcement officer and have to retrieve those items. Typically, what the court does is allow an individual to return under circumstances to retrieve groceries, clothes, so on and so forth. The items that are listed on that particular document are actually pertinent to his job, pertinent to his ability to travel through that job. One of the most specific things, and I think we're probably relatively in agreement on most things, but for the iMac computer, Your Honor, I'm of the opinion or of the understanding that there are 2 iMac computers in that home. There is a Apple notebook in that home and 4 to 5 iPads in that home. Certainly, it's not Mr. Butkowski's attempt here to diminish their ability to be connected, whether it be to the internet or any other device that they choose. However, the specific computer that he's asking for has a significant number of files, and if he were to leave that there, he would, and just take copies of them, he would not have a device that would connect to those files under. I believe at this point that the alleged victim only has a guest account on that computer where he has an administrator account. Again, we need specific files. There are several devices in the home. It's not an effort to keep them from doing what they need to do, but more so an effort for him to do what he needs to do as well. So we're going to ask the court to allow him to return to the home with the notion that he retrieve those particular belongings. And again, I think it's imperative that he be permitted to work with this particular action.
Or are you going about?
Your Honor, I'm sorry, Your Honor, I didn't mean to interrupt you. Your Honor, there's a list of items that Mr. Butkowski has requested from the home. We provided the prosecutor with, at least from my client's perspective, out of 11 items, Your Honor, she's agreed to 9 items to be retrieved. There is one personal home computer, Your Honor's iMac computer, which we believe should not be provided, Mr. Butkowski. And, Your Honor, certainly, we have no problems with him having his work-related computer, his work-related iPod, his City of Avon Council iPod as well, or iPad as well. That's not a problem. We do disagree with the iMac computer, Your Honor. Your Honor, in fact, the home computer, Your Honor, which I believe also the children have access to. Your Honor, my client's been locked out of the internet, so to speak. She's been given a guest password.
Could we do this? Because I'm going to have some difficulty making a decision on that. Could you, 2 attorneys get together and see if you can work it out? And if you can't work it out, then I'll make a decision.
But I don't think at this particular juncture, Mr. Ford has not really laid out a specific reason for not getting that computer. When I indicated there are 2 of those computers in the home and a notebook in the home.
I hear you.
It's kind of based
just saying, have you talked?
No, not at all.
Why don't you guys get together while you're here and see if you can work something out? If not, then I'll make a decision. But I'd prefer if you guys work it out.
If I may, Your Honor, and I just want to make sure I understand this correctly, if it's work computer that he has from his employment, that's not a problem. The home computers is the issue, Your Honor, and to provide Mr. Merrill with the potential issues, Your Honor, is we have a forensic report from our computer expert which indicates that potentially our client's data from her cell phone has been uploaded from her cell phone and retrieved on certain devices in the home, as well as devices, potentially Mr. Butkowski or someone else is at City Hall during council meetings, or potentially at their rental property in Elyria, Ohio. Your Honor, we have the report we provided to the prosecutor. So yes, Your Honor, we do have a reason to keep that computer in the home.
Your Honor, if it's been forensically examined, then they certainly don't.
It's not again.
It's been examined.
We could talk to each other and try to resolve it, and then if not, I'll make a decision.
Hey, Judge, we do have a date for the protection order hearing, if it's acceptable with the court, January 29th at 11 a.m.
Okay, we'll do that. So if you fellows can talk, come back and let us know